I want to start with something that happened to me last March. I'm 57 years old. I've been paying bills my entire adult life. Mortgages, car loans, utilities, credit cards. I thought I knew how this worked. I thought I was too experienced to get played. Then, I opened my bank statement and saw a $34 charge labeled Account Maintenance, a senior tier. I called the bank. A young woman with a pleasant voice explained it was a standard fee for accounts in my age bracket. I said okay and hung up. I sat at the kitchen table for a moment. Then something hit me. What age bracket? I never signed up for a senior tier. I never agreed to that. I called back. 3 transfers and 47 minutes later, the fee was reversed. The supervisor, very quietly, told me that fee shouldn't have been applied. That was my wake-up call. After that, I started digging. I talked to a consumer attorney friend of mine named Dennis, who's been practicing for 28 years. I called the CFPB. I read through the Older Americans Act until my eyes hurt. Here's what I found. And it made me furious on behalf of every person in their 50s, 60s, and 70s who's just paying bills and trusting that companies are playing fair. They're not always. Fee number 1, the senior account maintenance fee. This is the one that got me. And here's the legal reality most banks don't advertise. Under the Equal Credit Opportunity Act and several state consumer protection statutes, financial institutions cannot charge fees that are structured specifically around age if no equivalent fee applies to younger customers for the same service. Targeting a fee to a demographic bracket without a legitimate documented service difference crosses into illegal discrimination territory. My friend Dennis calls it age-based price padding. It shows up in bank accounts, investment accounts, and even some insurance policies. What to do? Pull your last 6 months of statements. Look for any fee that includes the words senior, mature, prime age, or any similar language. Call and ask them to explain what specific service that fee covers. If they can't, demand a refund. In writing. Fee number 2, predatory loan origination. Fees on reverse mortgages. My neighbor Harold, 71 years old, widower, sharp as a tack, got approached by a reverse mortgage company 2 years ago. Good guy, needed the liquidity. He came over to show me the paperwork one evening. There was an origination fee listed at 4.2% of the home value. I looked at him. He looked at me. The HUD-approved limit for reverse mortgage origination fees is capped at $6,000 or 2% of the first $200,000 of the home's value, plus 1% of the remaining, whichever is greater. Charging above that cap is a federal violation under the Home Equity Conversion Mortgage Program. Harold's fee would have been nearly $11,000 on his $260,000 home. He would have lost $5,000 illegally on day 1. He didn't sign. We called HUD together the next morning. What to do? If you have a reverse mortgage, or are considering one, verify every origination fee against HUD's published guidelines at hud.gov. Any lender charging above the cap should be reported to the FHA immediately. Fee number 3, unauthorized care coordination. Fees in assisted living facilities. This one is brutal, and I'm going to be honest. It hits close to home because my mother spent her final 2 years in a memory care facility. After she passed, I went through the bills. There was a recurring $175-month charge for care coordination services. I assumed it was legitimate. I assumed everything was legitimate. When I finally asked what it covered, the administrator couldn't give me a clear answer. Different services were mentioned each time I asked. Here's what elder law attorneys will tell you. Under the Nursing Home Reform Act and regulations enforced by CMS, Centers for Medicare and Medicaid Services, skilled nursing and many assisted living facilities cannot charge for services that are already bundled into the base care rate, and they must disclose in writing exactly what every separate fee covers. A fee you can't get a clear answer on is a fee that likely shouldn't exist. What to do? Request an itemized written explanation for every line item on a care facility bill. Compare it against the original contract. Contact your state long-term care ombudsman if charges can't be justified. They investigate these for free. Fee number 4. Inactivity. Fees on Social Security direct deposit accounts. Here's one that surprised even Dennis when I mentioned it. Some prepaid debit accounts and certain bank accounts marketed to Social Security recipients have buried in their terms a dormancy or inactivity fee, charged when you don't make a certain number of transactions per month. The problem? The Electronic Fund Transfer Act, combined with Treasury regulations on federal benefit payments, restricts what fees can be levied on accounts receiving direct deposited government benefits. Accounts receiving Social Security, SSI, or VA benefits are subject to specific protections, including limits on fees that could erode benefit payments. The Consumer Financial Protection Bureau has successfully pursued cases against institutions charging these fees on government benefit accounts. In plain English, they're not supposed to touch your Social Security money with fees like that. What to do? Check your Social Security direct deposit account for any inactivity, dormancy, or minimum balance fees. If they exist, call the CFPB at 1-855-411-2372. Fee number 5. Duplicate billing for Medicare Supplement, Medigap, services. I spent an afternoon last fall going through my Medigap statements with a magnifying glass, literally, and I found something I almost dismissed as a mistake. A claim had been submitted twice for the same procedure. The insurance company paid once. The provider billed me for the balance, framing it as my responsibility. This is a known pattern. It's called duplicate billing, and when it results in a charge to the patient for a service already paid by insurance, it can constitute fraud under federal anti-kickback statutes and state insurance regulations. I'm not talking about legitimate cost sharing. I'm talking about being billed for something the insurance company already covered, and the provider hoping you won't check. What to do? Request an explanation of benefits, EOB, for every claim. Match every provider bill against your EOB before paying a single dollar. If something was already paid, don't pay it again. Report discrepancies to your state insurance commissioner. Fee number 6. Document preparation. Fees on fixed income loan products. When I refinanced a small personal loan 2 years ago, there was a $295 document preparation fee on the closing disclosure. I paid it without thinking. Later I learned, in many states, document preparation fees charged by non-attorneys, particularly on loans targeting older borrowers on fixed incomes, are either capped by statute or outright prohibited as the unauthorized practice of law. 17 states have specific restrictions on doc prep fees. Several states, including California, Florida, and New York, have additional senior consumer protection laws that limit what can be charged at loan closing to older borrowers. What to do? Before closing on any loan, ask your state attorney general's office website about document preparation fee limits. It takes 5 minutes and could save you hundreds. Fee number 7. Voluntary insurance add-ons that weren't voluntary. The last one is the one that made Dennis genuinely angry when I described it to him. A man I know, 63 years old, a retired mechanic named Pete, financed a used truck. 3 months in, he realized he was paying $47 a month for credit life insurance and $31 a month for debt cancellation coverage that he had no memory of agreeing to. He went back to the dealership. The boxes on the finance form had been checked before it was put in front of him. Under the Truth in Lending Act, Tyler, and FTC credit practices rule, add-on insurance and protection products must be truly optional and must be disclosed as separate costs. Checking boxes on behalf of the customer or presenting pre-checked forms without clear disclosure violates federal law. Pete filed a complaint with the FTC and his state attorney general. He got 14 months of premiums refunded. What to do? Pull out the paperwork for any loan you've signed in the last few years. Look for add-on products, credit life, gap insurance, debt protection. If you don't remember agreeing to them, request the original signed documents. If boxes were pre-checked, contact the FTC at ftc.gov. Complaint. Here's what I want you to walk away with. I'm 57. My parents trusted every bill that came in the mail because that's what people did. You paid what you owed and you didn't make a fuss. But paying what you owe and paying what they say you owe are two different things. You have rights, specific legal, federally protected rights, and the companies that violate them are counting on the fact that most people won't check. Check. Every statement, every bill, every closing disclosure, every care facility invoice. And if something doesn't add up, don't hang up the phone until it does.